Tuna imani kubwa hii kesi lazima tutashinda, kwa sababu hakuna mtu ana ruhusa ya kumiliki mbegu, kwa sababu hata huyo mtu ni mbegu.
It is the cry of oppressed African farmers in Kenya by the government outside Machakos High Court premise on 20th May 2025.
Na tuna haki ya kutetea mbegu zetu kwa sababu ni mbegu zetu za kiasili ambayo tuko nazo kama wakulima.
Protesting against the Kenyan Seed and Plant Varieties Act Cap 326 of the year 2012 and Seeds and Plant Varieties Regulations of the year 2016, now petitions at the High Court of Kenya by the farmers.
The state has not tendered any evidence as to why it passed this particular law to limit the rights of the farmers.
The indigenous farmers feel oppressed by the law, and today the court premise is full of farmers. Inside the Machakos High Court, the petition has just begun, with lawyers representing over 15 community groups challenging the government on the matter.
This entire case is to argue and show that the inclusion of indigenous seeds and plant varieties in that act is contrary to the Constitution, and therefore these provisions should be declared unconstitutional.
But one would ask why the July 2022-2024 petition, and what are the issues in contention?
Our seeds' rights are being violated by what has been drawn.
Criminalizing farmer seeds means hunger. It is surprising that the state want to treat farmers differently when it comes to the rights. In a way that inspectors can be allowed to go to the farmers' field, farmers' houses, take seeds, take whatever they want because they feel like it. Therefore, to us, it's very important that this case is concluded and farmers are able to save their seeds.
In a press briefing outside the Machakos High Court, which slotted 27 November, ruling on the matter, community groups argue that farmers' futures are at stake since the inception of the 2012-2016 law, which they term as criminalizing farmers.
The Constitution of Kenya specifically and expressly provides that you cannot limit the right to culture. Any law that is passed limiting the law to culture is unconstitutional.
But farmers are not happy. They feel the law has been a thorn to them, and it is important for them to have amendment and removal of oppressing clauses.
Even our government is still lamenting we have no seeds in Kenya. So why can't they empower small-scale farmers to be able to multiply those indigenous seeds?
The Law Society of Kenya, appearing as an interested party to the matter, backed the petitions opposing the Kenya shilling 75,000 requirement to register seed ownership and 10,000 Kenya shillings annual fee.
So until then, we really hope that the court agrees with us, and if it does not, then we shall look at our options then.
Today's meeting setting the pace for Judgment Day on 27 November, with farmers and petitioners at large walking shoulders high that the ruling will favor them and ease the burden on farmers.
And the small-scale farmers are about to get their rights and freedom and sovereignty in their food and seeds.